Hello, we are starting to explore subjects of international law by examining states. When exploring the history of international law, I have already explained that states are a form of organizing a society politically that is relatively new. States have not always existed. They are something that's created at the end of the 17th century. We want to put the origin in the Peace of Westphalia, so it has very specific geopolitical and economic coordinates. However, this political model of organizing society has been expanded worldwide through colonization and decolonization. So since the 17th century until the end of the 20th century, we have witnessed how the nation-state has established itself first in the Americas and then in Asia and in Africa. It is normal to say that the state is the primary subject of international law. What do we mean by this? Well, we mean that there's no other entity with more power or power above the state. Every other subject of international law has personality because states have consented to it, because states have given it to them, so they have secondary personality, if you want to, derived from the state's consent. This is a simplification in a way because many non-state actors have had an important role in shaping international law as we know it today. However, this simplification responds to the working definition I provided about what we are considering subject of international law for the purpose of these explanations, which is those entities with rights that are recognized in international norms and that can activate them in international fora. So as primary subjects of international law, states display all the manifestations of international legal personality that we have explored in an earlier session. They are rights and duty bearers, and they can bring their claims before international institutions for breaches of international norm. They are also responsible for breaches of international law, so other entities, other states, other subjects can bring claims against them, and they have to provide remedies. And also, finally, they play a central role in the creation and implementation and enforcement of international rules. So what is a state? The same way we do not have a general definition to explain international personality, there is no accepted legal definition of what we mean by a state. However, there are two main approaches when we try to explain this issue of what is a state. One is to associate the concept of a state with sovereignty. So a state is the one who is sovereign, and we'll look at what we mean by this. The state is the one with the ultimate authority. Another approach consists on determining which characteristics must be present for a state to exist. If an entity possesses, displays these characteristics, then we say this entity is a state. In any case, the consideration of criteria to decide whether an entity is or is not a state is only relevant if the statehood is contested. Well, this happens when new states are created or when new entities declare themselves new states. So let's look into this idea of sovereignty. Once a state exists, it is sovereign. Basically, it refers to the state as the ultimate authority and its decision-making powers. Because there's no authority above the state, all states are also equal. Equality is intrinsic to the concept of sovereignty. There's nothing above the sovereign, so all those who are sovereign are equal. As a result, no other states or institutions can interfere in their domestic affairs. They also enjoy total and exclusive jurisdiction and immunities in the territory over persons over which they exercise their sovereignty, and there is a presumption that the state has competence to activate all the powers that are possible that are associated to legal personality in international relations. unless they have consented to specific limits. We will immediately see that there is some nuance to this total power and sovereignty, but in any case, I want to highlight that sovereignty is intrinsically linked to the concept of a state, and as such, the concept of territorial integrity and independence. So the state is sovereign, and the idea of a state, the concept of nation-state as we know it today, is linked to a territory and to the fact that others cannot interfere, cannot within the limits of that territory. A state's consent is required for rules to be applicable to them or for third parties to intervene in their disputes. So in practice, the equality derived from sovereignty is mitigated or modified in practice and legally by different factors. So first of all, geography, equality of states. In practice, it changes by different factors, such as whether or not a state has a coast, a long or a short continental shelf, whether it has an archipelago, or if it is itself an archipelagic state like the Philippines or Cuba. If these circumstances concur, the states are affected by different legal regimes, and also they have different access to resources. Of course, access to natural resources of a country in international relations provides different leverage. So as a second factor that I have highlighted here, we have wealth. So the wealth of a state, that's also influenced by its geographic position, affects some rules in international law. For instance, the World Bank institutions were not created to deal with poverty. However, through their interactions with the third world, this became a central focus of their agenda. So the development agenda is central to international financial institutions, and this is because of their attempt to deal with different levels of wealth among countries. Also, some partially failed attempts to create a new economic orders have resulted in specific rules for the so-called developing countries in international trade law, and these rules take into account different wealth, the different level of wealth of nations. In addition, we can also think of rules where states are asked to reach an equitable solution, and we will see when we explore international law of the sea that again the level of wealth, development, reach, access to resources of a country can be taken into account to resolve these disputes. Obviously, too, the size of a country, either because it's big in terms of population or is big in terms of size. I have here chosen Russia, China, and India, will also influence on the leverage of that country in international relations, as it will be the fact that they have a big army, or they have nuclear weapons, or access to intelligence from other states. All these factors will have an impact not only in their importance in international relations and the power they display in international relations, but also in the rules that will be applicable to them. Apart from factors that can influence the legal regime applicable to states, or they give them different leverage in international relations, the sovereignty of a state is not absolute. First of all, states can consent to limits to their sovereignty. They do this all the time. They can consent to be bound by treaties or become members of an international organization to which they might even delegate sovereign competence. For instance, many states members of the European Union, have decided to resign to lots of their powers over controlling their borders or over their national currency. In addition, states cannot act in any way contrary to peremptory norms of international law, whether they have consented or not. States have also resigned to use armed force in their international relations, delegating the power to decide whether or not a threat to peace and security exists and how to react to it. They have delegated that power to the United Nations Security Council. Also, even without their consent, in practice, some international bodies monitor how states behave in relation to human rights, particularly at United Nations level and within the Inter-American System for the Promotion and Protection of Human Rights. Then there are other more problematic limits to the sovereignty of states. It can be argued that most states have also resigned to possess nuclear weapons, but this is also disputed. And some argue that states who are unable or unwilling to protect their own population must accept humanitarian intervention by other states with or without their consent. As I said earlier, the problem of deciding whether a state exists or not will only present itself when a new entity claims to be a state. This is not a problem the United Kingdom will have, for instance, of whether others or the United Kingdom considers itself a state. This is a topic linked to the creation of new states and how new states come into being, a topic you will cover with Professor Castellino, in particular in relation to the right to self-determination, decolonization, and title to territory. This brings us to the issue of what criteria must be met for an entity to be considered a state. On this question, you will find that authors cite the 1933 Montevideo Convention on the Rights and Duties of States, as it happens with other treaties or specific provisions of some treaties, such as Article 38 of the Statute of the International Court of Justice or the Vienna Convention on the Law of Treaties. The reference to the Montevideo Convention does not mean that the treaty is applicable as such to all states. In fact, only 16 states from the Americas are parties to this treaty. However, it contains a list of qualifications of criteria that must be present to categorize a state as a state. These criteria have been used as a reference in the practice of a state to decide whether to recognize or not another state as such, and they are widely used by scholars too. So they are considered customary law. According to Article 1 of the Montevideo Convention, a state needs a permanent population, a defined territory, an effective government, and capacity to enter international relations. First of all, a defined territory means land territory. Unless climate change or technology redefine in the future this requirement, and this is not explicitly included in the Montevideo Convention, but I don't want to forget to tell you this. A territory means a land territory with independence that states with the land also get the airspace, the underground, and if they have a coast, part of the waters adjacent to their court. Also, a defined territory does not mean total definition of borders. Many states that are considered states have some borders under dispute. I have chosen here the example of India and Pakistan over Kashmir, but many other examples exist. It also requires a permanent population. In the Western Sahara case, the advisory opinion of the International Court of Justice declared that the population can be nomadic, and it still fulfills the criteria of being a permanent population. Also, there is not a minimum limit in terms of size or number of people. A state can be indeed very small. The existence of an effective government that controls the territory claimed as part of the state and the territory claimed as relevant for statehood is also necessary. As with all the other characteristics we have looked into, this is only relevant when the statehood itself is questioned, many states have continued to be considered states despite long periods without a government. So this was the case, for instance, of Belgium during 541 days between 2010 and 2011. Somalia has had long periods of no government with control over the vast majority of the country, and also Afghanistan. Finally, states must be able to enter international relations with other states. As I have said several times, the presence of these characteristics becomes really relevant only when a state wants to be recognized as such in international relations. If an entity is not recognized as a state, it will hardly be able to engage with other states in equal terms. This is where the issue of recognition of states and recognition of governments becomes central, and we will explore that topic in another video and in class, especially through case studies for our seminars. Thank you.